On the record, Your Honor.
This is case number 21-CR-018, State of Ohio versus Joshua Dennis, appearing on behalf of the state's prosecuting attorney, Daniel Collins, prosecutor Aaron King, appearing on behalf of the defendant's attorney, Daniel Witt. And you are Joshua Wayne Dennis?
Yes, Your Honor.
All right. Mr. Dennis entered pleas guilty to count 1, failure to provide for signal police officer a third-degree felony, and count 2, receiving stolen property, a fourth-degree felony. The matter was referred for a pre-sentence report. I have received that and reviewed the same. Have each of the attorneys received a summary of that report?
Say aye, Your Honor.
Yes, Your Honor.
All right. We have the state.
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. We'll just kind of go through some of the facts here quickly. This happened back on December 28th, 2020, when Officer Cooley responded to a residence on Broadway Street in Lynchburg in reference to a report of a stolen vehicle. As Officer Cooley approached the vehicle, the defendant was seated in the driver's seat. He took off. The pursuit ensued. The defendant drove through several yards, drove through a fence. He entered the Masonic Cemetery. Once he entered the cemetery property, he struck and damaged several headstones. The vehicle sustained disabling damage. At that point, the defendant jumped out of the vehicle, took off on foot into a wooded area. A search ensued. About 2 hours later, he was finally taken into custody. They had to bring in OSP from his helicopter, and they located the defendant. And looking at the defendant's criminal history, he does have a prior felony record. He's been convicted of 2 separate felony possession offenses. He has served a term of incarceration, and he also has various felonies pending in Clinton County. He's got an F4 grand theft of a motor vehicle, an F5 theft, F3 theft from an elderly person, and 3 counts of F5 B&E currently pending. So, based on all that, it is the state's position that the defendant is not able to plead control and would ask that he be sentenced to a term of incarceration. There also is restitution in this case, Your Honor. The $485.89 to the Masonic Cemetery, $1,000 to Dustin Storer, Mr. Storer was the owner of the vehicle, and $375 to Charlotte Bailey. That would be damage that was done to Miss Bailey's yard when the defendant drove through it. Thank you.
Ms. Witt?
Yes, Your Honor. Ever since I first met Josh at the preliminary, he's been extremely apologetic, remorseful of the whole situation and all of the incidents. Everything Mr. King said is absolutely true. His last convicted felony was in 2010, so over 10 years ago. Just a little bit more about him is that he has never been in treatment, but yet he started smoking cigarettes at 7, I think pot at 10, and meth by the time he was 13. So he's had a long-standing drug use problem and a lot of psychiatric problems that go along with that. So we asked the court for him to be sentenced to STAR and a chance at rehabilitation and recovery in a lockdown facility.
That's correct. He was convicted in 2016.
Oh.
This is his last conviction. All right. Anything else?
No, you're good.
All right. Mr. Dennis, anything you would like to say?
Yes, Your Honor. I want to apologize to everybody that I affected. And to John, destroyed my children that I've hurt, the people that I've hurt. And I'm just like a chance to be a normal, productive member of society and get away from the drugs. I need help. I need help. Thank you.
And how old are you, Mr. Dennis?
I'm 33.
Okay. Anything else you'd like to say?
You're on.
Well, the record shows you have 3 prior felony convictions, 2 in 2010, for aggravated possession of drugs, 2010, 2 counts, and then in 2016, it's attempted illegal possession of chemicals and manufactured drugs, which would make 4 degree felony, and you served 2 previous prison terms. Now, the fact that you have a drug problem is certainly not news to you. You know about it better than anybody else. And you say that you say, I need help. And yet I see absolutely nothing in this record that shows me that you've done anything to help yourself. You know, there's an old saying, at least my family, was that the Lord helps those who help themselves. Well, the law's kind of the same way too. If you help yourself, then the law's going to take that into consideration. But you're saying someone else has got to help me. You know, the fact of the matter is, people that deal with problems like this, in the end, it comes down to that. No one else can help. They can provide the means for the help, but they can't help you have to help yourself. Now, the other thing is that you have been apparently on a crime spree involving a lot of different individuals. And you have these cases pending in Clinton County that involve 3 different break-in enterings in other person's property, by structures. You have theft from an elderly person pending. And so whatever I do here, I don't think it's going to, if I were to put you in treatment, it's not going to work because you're going to go from here to Clinton County, and you've been there before, and you've been sent to prison from there too. You know, first thing Judge Rudd is going to look at is say, what happened to Judge Austin? Must have lost his mind. And he's going to send you to prison anyway. And that's not going to happen because, you know, maybe I have lost my mind, but I don't know it. But I do know this, that you're not amenable to community control. So it's a judgment over the court that should be, and are hereby sentenced to a term of 18 months in incarceration in the Correctional Reception Center in Florida, Ohio, for count 1, and count 2 to a term of 6 months. Now, those are ordered to be served consecutively to each other for a total of 24 months. And the reason for the consecutive sentence is that your history of criminal conduct shows that that sentence is necessary to protect the public from future crime. Also, your offense involved several different victims. In count 1, 3 different people whose yards you tore up, plus the Masonic Cemetery. And then, of course, count 2, Mr. Store's vehicle. And so the court finds that the offense is committed as a course of conduct that involved numerous victims and separate harm to each one. One single prison term will not adequately reflect the seriousness of the offense. Now, according to the sheriff, you were arrested on the 29th of December, so that gives you 100 days of jail time credit. Now, upon completion of your prison term, Mr. Dennis, it is mandatory that you be supervised under post-release control supervision by the adult parole authority for a period of 3 years. And you'll be supervised on the terms they set. The court has nothing to do with that. And if they determine that you have failed to comply with those conditions, then they will be entitled to return you to prison for a period of up to 9 months for any one violation, up to a maximum of half of your prison term, which in this case, half of 24 is 12. So that would be the maximum cap for violations for that by the APA. But commit a new felony. Then, in addition, whatever sentence can be imposed in that new felony case, the judge in that case, that judge is also authorized to sentence you for committing that crime while under post-release control, in this case, to an additional period of 1 year. Whatever time left on that 3 years post-release control, whichever greater that occurs, that must be served in the second legal sentence in the case. And also, the mention of difference that count 2, your post-release control is optional. For the cases I haven't looked at every count, even though it's mandatory count 1. So it's optional count 2, which will be undeveloped for 3 years in count 1. Now, you're also ordered to pay restitution to the Masonic Cemetery in the amount of $485.89, and to Mrs. Bailey $375 for the damage caused as a result of the commission of the first count. And then, actually, it's $1,100 or $1,000? Okay, I can't remember right. $1,000 to Dustin Store for the damage to his vehicle, which is actually for both the second count and the first count, since it was damaged in the chase. Those amounts will be required to be paid through the victim witness escrow account, victim witness office, and you'll pay the service fee connected with that service. Now, this that part of the sentence cannot be discharged from bankruptcy. Even if you serve your entire time, it will still remain there and be enforced through various means, including bringing back to court, and if you have ability to pay it, be held in contempt in the future. It will not go away until you pay it. Now, there are also ordered court costs, which judgments order execution. Judgment is granted an execution order, and if you fail to apply and pay that, then the clerk can collect that through various means, including levy from bank accounts, wage earnings, or other assets you may have. If that does not collect it, then once you complete your prison term, not while you're in prison, but once you complete it, you could be ordered to do community service in this county and be given credit for an hourly rate set by the court. Each hourly worker reduce your credit by that amount until it pays. All right. Is there anything further to counsel? All right, for remand custody.
Step back around the screen. Back to Deputy Counsel, please.
Okay, Jonathan Burton. There are two cases for the court involving the same defendant, both State of Ohio versus Jonathan B. Burkheimer. The first case is case number 20 CR 268, and aggravated possession of fentanyl-related compound. And case number 21 CR 37, failure to appear, and case number 20 CR 68. Present for the state, prosecutor Collins, assistant prosecutor Kane, present for the defendant's attorney Danielle Witt. Are you Jonathan D. Burkheimer?
Yes, I am.
All right, Mr. Burkheimer entered pleaded guilty to both of those for the charges in each count, as I just outlined. In each case, just outlined. Court ordered a pre-sentence investigation report. I have received that and reviewed it. Have each of the attorneys received a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained within the plea agreement.
All right, Ms. Witt?
Yes, Your Honor. We asked the court to follow the joint recommendation of the state. Jonathan has been in residential treatment at the counseling center since March 18th. He has been doing really well there. He told me this is his first time in treatment. It's kind of opened his mind to a whole different way of thinking. He's also involved in the vocational program instruction. So he's doing really well. We just asked the court for the opportunity to allow him to continue in his treatment and be under community control.
All right, thank you. Mr. Burkheimer, anything you'd like to say?
Yes. I'd just like to thank the court for giving me the opportunity to be OR down there to the counseling center. It's opened my eyes to a new way of living, knowing that I don't need the drugs in my life. I've got a lot of education. I mean, there's still a lot of process for me to do, but I surely enjoy it. And I know there's a better life out there than rather than being on the drugs that I've been on all my life. I've been really lucky up to this point. I never thought at 48 I would have a felony. And, but I just want to say thank you for giving me the opportunity to treat me.
Okay. Well, I do have a report from the counseling center. It's a good report. It's dated actually this morning from Mr. Stradlin at the User Entry Center. In case you are doing well. I'll note from your report you do have a previous felony conviction. That was in 1993, a long time ago. Since then, like you said, you've been really lucky in that apparently, although you've had these ongoing substance abuse problems, you've had a variety of minor misdemeanor offenses. When I say minor, I don't mean by class, but by seriousness. although one was a minor misdemeanor, reckless, disorderly conduct, and some of the driving offenses. So, you are lucky that you haven't gotten yourself in so deep that, a prison term is appropriate. But at this point, and you may be seeing, this point the court finds that you are being including control, as you are doing well in treatment, so the court is going to give you the opportunity to do that. So it's the order of judgment of court in each of these two cases that you be sentenced to a term of 3 years of community control under the supervision of the Highland County Probation Department. Now, you'll be required to comply with the conditions about the state and they apply in both cases. First of all, you'll obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed, and be truthful in all statements you make, and answer some questions that you give from the probation department regarding your supervision. You must keep the probation department informed of your residence and place of employment at all times, and change either without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission of your supervising officer. You have to have a pass with you when you're out of state. You may not enter upon the grounds of any correctional facility, or may communicate with or attempt to communicate with anyone who is an inmate or prisoner in a facility without prior written permission. Now, because of your conviction in the 20 CR 268 case, you are not permitted to purchase, possess, own, use, or have under control any kind of a firearm, ammunition, or dangerous ordinance under both federal and state law. And to do so would be a separate crime. It's also a condition that you not have any of those items while you're on community control or any other weapons of any type. Now, you're not permitted to purchase, possess, use, or have under control any kind of controlled substance, a drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to a controlled substance or drug of abuse, or any instrument, device, or thing that may be used to administer those or prepare them for administration unless you have a lawful prescription for that. And if you do, you must provide a copy of that within 24 hours of your receipt to the probation department. You're to submit to drug testing when and as requested. You're not to purchase, possess, use, or have under your control any kind of alcoholic beverage or be present in any places where the sold or being consumed, even if that is otherwise lawful. You're not permitted to associate with a co-defendant in this case, if any, or any other person has a criminal record, a member of a gang or a criminal group, or any person who has a past or future, unless you commit a criminal offense that violates these conditions, unless that's approved in writing by your supervising officer. That would also apply to family members that might fall within that definition unless you were living with them immediately before you committed this offense or offenses. After the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type relationship with another person without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law to the probation department not later than the next business day after that occurred. You must provide your supervising officer financial information records or your ability to pay any fees or costs of your review. Now, if you're referred by the probation department for any evaluation or assessment or any further treatment or counseling or therapy, you're to submit to that, and if there's any kind of program you recommended, then you're to enroll in and complete that successfully during the period of this community control. You're required to successfully complete the residential treatment program and aftercare at the counseling center. And aftercare means once that you're released from residential treatment, whether it be transitional housing or sober living, following up with meetings, counseling, that type of thing, you're to do whatever it is they recommend. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your vehicles, your residence, or any other vehicle or property or place where you're found or that's under your control at any time by any officer of the probation department. There'll be no fine imposed in either case, and no license suspension imposed in case number 20 CR 268. Now, you're also ordered to pay the court costs and make a payment arrangement for the clerk to do that. And it's also ordered that you pay the court costs as a substitute court. And that means that if you don't make those payment arrangements, the clerk can collect those through various means, including levy on bank accounts, wages, earnings, or other assets you may have. And if that doesn't collect it, then the court could order you to do community service and give you credit for each hour you work in an hourly rate set by the court each hour you work would reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file written notice of that with the court, and they will serve you with a copy. You'll be entitled to have a hearing and be represented by an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your probation control and then sentence you to prison in each case. In case number 20 CR 268, that sentence could be 12 months in prison and fine of $2,500. And in case number 21 CR 37, that sentence could be 18 months in prison and a fine of $5,000. If that should occur upon completion of that prison term imposed by the court, the adult parole authority could, at their option, place you under post-release control supervision in both cases for a period of up to 3 years. They don't have to, it's optional, but they will make that decision on the court. If they do, then you'll be supervised under those conditions by a parole officer, and if the parole authority determines that you have failed to comply, then at that time they can revoke, or they can require you to go back to prison, I should say, for an additional period of up to 9 months under one violation, and the maximum half of your prison term for all violations. But if your violation is a new felony, then in addition to whatever sentence the judge in the new case imposed upon you, that judge could also sentence you in this case to an additional period of 1 year, or a time left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. All right, is there anything further from counsel? All right, now you're discharged from pretrial supervision conditions. None of those apply anymore, house arrest, and those kinds of things. But you will need to see the probation department, go down there for an appointment, or right away after you get down here, make an appointment to be taken into the supervision program. You'll have a different parole officer.
Do you have to be the misdemeanor court or the probation or the?
County, same county, it's county probation department, same court, but it's going to be down here at probation department across the line. So as soon as you get done here, you go down there. All right, anything further?
No.
All right, thank you. Derek Myers. Okay, this case number 20 CR 270, State of Ohio versus Derek W. Myers. Present on behalf of the state is the prosecuting attorney Anderson Collins, assistant prosecutor King. Present on behalf of the defendant's attorney William Armentrout. And are you Derek W. Myers?
Yes, sir.
Mr. Myers is entered plea of guilty to aggravated possession of fentanyl-related compound, a fifth-degree felony. The court referred the matter for a pre-sentence investigation. I have received that. Also, I have received the confirmation from Ms. Sturgill, the drug court coordinator, that the defendant does meet the criteria in her estimation for admission to the program, and the court accepts his application. All right, this on behalf of the state.
Only with the payment plea here, Your Honor.
I'm proud we have defendant.
John, we asked the court to follow the plea agreement, placing him on probation. Obviously, at first blush, we think it's PSI, 12 prior felony convictions would be. At one point in time, we didn't even think to ask for probation. The court's already aware of his history. Speaking to Derek this morning, he's gained, how many pounds have you gained, Derek?
I weigh 230 pounds now.
He looks a million times better than he did a couple months ago. He's still at the institution, tells me that he just basically loves it there. And there were those of us, myself included, that were skeptical whether he would even show up today. But he seemed to make great progress. We asked the court to accept him into the drug court.
All right, Mr. Myers, anything you'd like to say?
Yes, sir. I just wanted to let you guys know, thank you for giving me this chance. And I'm doing real well with the program. And I feel 100% better.
Okay, anything else?
No, sir.
All right. You may be seated. Now, Mr. Myers, let me first start out this way and say this, is that when I started this job 12 and a half years ago, if you'd have told me that I would even think about getting community control of somebody with 12 prior felony convictions. I would say you've lost your mind. They call the sheriff and take you to the funny farm. But things have changed, and the court and I have changed, and I realize the value of treatment and the importance of treatment for those who are serious about it. And you do have 12 prior convictions, but the most recent one was in 2014, and both of them were actually back older than that. And so I am going to give you a chance, because you, as in your attorney said, there was some wondering in my mind at least whether you would actually show up or just look at. A lot of people look at, I want to get into treatment so I get out of jail, and then they get it for 3 days and they walk away, because those people are not jailers and they're not going to tackle you or take you into custody. And so people just, it's just an easy way to escape, basically. But you have shown up, you've stayed in treatment, and so that to me gives me a feeling that you do deserve the chance. So I'm going to give that to you. Now, regular community control, your supervisor or probation officer, and the goal of that is to basically keep people out of prison, give them a chance to get back in the community and not offend, and thereby not become an additional burden on the taxpayers and being impartial. Drug court is different. Drug court is still be community control, but it is tougher and it's more intensive, and it's designed that way because it is for people who are focused not just on staying out of prison, but on getting sober and staying sober. And the reason we focus on the treatment and the sobriety is people that stay sober seldom commit felony offenses. And so that's the focus. And you'll be in residential treatment for a period of time, probably in a transitional housing, and then you'll be required to be going to treatment. You're subject to being tested, calling in for testing once you get out of your treatment facility every day, calling in every day, being tested at least initially 3 to 4 times a week, and having a report for that. And if you don't show up, that needs to be a failed test and subjects you to sanctions. The treatment is much more intensive, including meetings and participating in the recovery community, and just basically changing everything about your life. And if you, I don't know what right now from reading the report, I read about 10 of these last night about your educational background. If there's a need for a GED or other training there, you know, they would work with you on that, work with you on a number of things. But that being said, I do not order people into the drug court. I accept it because you have to be willing to do this. And if you're not willing to do what it takes in the drug court program, then you just need to stay in the regular community control and try to stay out of prison. But we have people that get through community control successfully that never get sober, and then they'll come back. And then we have others who, you know, they don't get through the program, and they come back and go to prison anyway. And so that's the question. Now, you have signed an application saying that you want to be in the program and that you acknowledge all the conditions this certain one over with you. Is that correct?
Yes, sir.
Okay. And you sat in on a session, I think, on Zoom
Yes,
the other day?
yes, sir.
All right. So at this point, is that what you still want to do? Because if you don't, I won't accept you. I'll put you on regular community control. But if you want in the program, and I think you should be, but again, it depends on you. It's like I told this man there earlier, Bob Perkins, because, you know, saying I want help, you know, the fact of the matter is, you're going to be the one to help yourself. The drug court, community control will provide you tools to help yourself. But kind of like I said, you know, we can give I give you a toolbox and say, okay, now you can build a house. But I'm not going to build it for you. You're going to have to take those tools and build your own house. And that's basically what we're doing. We're giving you tools to build your own home of recovery. Yeah, it'll be up to you to do that. Now, is that what you want to do?
Yes, sir.
All right. Well, then the court is checking you into the drug court program, and it's order and judgment of the court that you be placed on 3 years of community control under these conditions. First of all, you'll be required to comply with all of the conditions of the drug court docket program attachments, which you have been provided and were filed in the file here with the court. You been overdose with Mrs. Sturber. Now, you're to obey all laws of all jurisdictions, conduct yourself in law-abiding manner on time, report when and as directed, be true in all statements you make in probation, and any answers you give them to questions they ask you about your supervision. You're to keep them informed of your residence and place of employment at all times, do not change either without prior permission. Do not leave the state of Ohio at any time without prior written permission, and you have to have that pass with you when you do go out of state. You are not permitted to enter upon the grounds of any correctional facility or any other, or to attempt to communicate with anyone who's an inmate in any such facility without prior written permission. I'm sure you already know this, but you're disqualified under both federal and state law because of this conviction and other convictions that you had from owning, possessing, purchasing, or using any type of a firearm, ammunition, or dangerous ordinance. And to do so would be a felony under both federal and state law. And it's also a condition of your control in the drug court that you not have any of those or any other weapons of any kind. Now, you're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug of abuse, CBD oil, kratom, medical marijuana card, or any other variant or analog of any controlled substance or drug of abuse that would have similar effects. And you're not permitted to have any thing that could be used to administer them or prepare them for administration unless you have a lawful prescription for any of those items. And again, no medical marijuana card, obviously. We're not letting you do that because if you're serious about recovery, it's just a crutch. Just like drinking is a crutch. That's why you can't drink.
I ain't drunk beer in 12 years, sir.
Well, that's good. But a lot of people, if they can't use dope, then they want to drink or they want to use medical marijuana. That seems to be the thing now. We've got some doctors in the adjoining counties that, apparently think that everybody has a right to have a buzz off, but that's not appropriate in recovery. Now, you are not to purchase, possess, use, or have under your control any, and you also have to submit drug testing when it's directed by the.
I get them about every other
Yeah,
day.
you're to do that, then requested by probation or your treatment team. You're not to purchase, possess, use, or have under your control any kind of an alcoholic beverage, nor may you be present in places where the soul being consumed is otherwise lawful for the reason I just explained. Not to associate with anyone as a co-defendant in this case or any criminal record or member of a gang or the criminal group, or any person who has a past in the future place you commit a violation of the law or these conditions. And obviously, it doesn't apply to people who are in recovery with it. After the date of this marriage order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship with another person without written permission. Does report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not the next business day after that occurs. You're to provide financial information records so your ability to pay your fees and costs of your review. Now, if you're referred for an evaluation assessment for any further treatment, therapy, counseling, training, or educational programming by probation or your treatment team, you're to submit to that. If there's any additional programming recommended, you're to enroll in and successfully complete that. And as I specifically said earlier, you can successfully complete your treatment plan as recommended. And you're to comply with all other conditions that I have specifically mentioned that are in the drug court docket program conditions that you sign and file with the entity. Now, by being placed under community control, rather than being sent to prison, you're deemed consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property places under your control or you're found at any time by any probation officer or supervising officer. There'll be no fine or driver suspension imposed. And if you're also to pay the court costs, make a payment arrangement for that as a condition. And if you fail to pay those, it's also a subsequent order that you pay that. And then in that event, the clerk could collect those by various means, including medical, bank accounts, wages, earnings, and other assets you have. If that doesn't collect it, then you could be ordered to do community service in this county and be given credit for each hour you work in an hourly rate set by the court. Each hour you work, you should judge by that amount, so paid full. Now, in the event that it's alleged that you have failed to comply with the conditions of the community control and drug court docket, then a written notice of that will be filed with the court. You'll be entitled to have a hearing, and you'll be entitled to be represented by an attorney. If the outcome of that hearing is that you have failed to comply, at that time the court will terminate you from the docket, and then sentence you to prison for a period of 18 months and fine you $5,000. If that occurs, then once you complete the sentence, the law provides that you could be placed under post-release control supervision for up to 3 years by the parole authority. It's their option, it's not mandatory, but they'll make that decision. And if they do, you'll be supervised on the conditions they set, and if they find that you failed to comply, then they can return you to prison, making sure a condition period of up to half of your prison term for one or more violations. But if your violation is a felony, then in addition to whatever sentence the judge in the new case imposed upon you, that judge is also authorized to sentence you in this case for committing that violation for an additional period of 1 year, or whatever time is left on that 3 years of post-release control, whichever is greater. And if that occurs, that will have to be served exactly as sentencing in the new case. All right, is there anything further from counsel?
Hang on.
All right, now you're now complete with pretrial supervision. You don't have to apply those conditions anymore, but you will have to apply for the conditions that's outlined. I see Mr. Arjun is over there, probation, see him about when you need to go down to make your appointment with the probation department. And then Mr. Parr will be your officer in the drug court.
All right.
All right, thank you.
Thanks.
Good luck, Darren.
Thank you, sir.
Dana Peacock. All right, this case number 21CR005, State of Ohio versus Dana Peacock, President of the States, Prosecuting Attorney Collins, and Assistant Prosecutor King, President on behalf of the defendant, and Attorney Kapner. And are you Dana Peacock?
Yes, sir.
Ms. Peacock has entered a plea of guilty to count 2, theft of the, from a person protected class at third degree felony. Count 1, identity fraud of the person protected class was dismissed. The court referred the matter for a pre-sentence investigation. Court, I have received that, as reviewed the same. Have each of the attorneys received a summary?
They got it.
Hi, Ron.
All right. On behalf of the state, your sentence.
The state is requesting that the defendant be sentenced to a term of incarceration. The victim in this case is 95-year-old Cynthia Young. The defendant had been Ms. Young's caretaker for 8 years. Ms. Young indicated that the defendant had been a loyal caretaker. She thought she could trust her. She was obviously wrong. This all started back in November of 18. The defendant would often handle Ms. Young's mail, and Ms. Young received an offer for a credit card from Capital One in the mail. The defendant discovered that offer. After that, she also took a picture of Ms. Young's driver's license so that she could have the information to open up the credit card. She did so. The defendant added herself as a user to the account. None of this was discovered until 2 years later, in November of 20, when Ms. Young's daughter was at the residence going through Ms. Young's mail, discovered an invoice, a statement from Capital One, knew that her mother did not have a Capital One card, and then it was all discovered that it was the defendant who knew the card. During the 2-year period when the card was being used, the card reached a balance of over $10,000. The defendant was attempting to make some payments on the card, but I think she got in over her head and stopped making payments. Based upon the defendant's conduct here in this case, and also based upon the wishes of the victim, the state is requesting a term of incarceration. There is no restitution in this case. Capital One has covered all of that. Thank you, Your Honor.
All right, Ms. Hammond?
Thank you, Your Honor. Your Honor, Ms. Peacock has made freely taken responsibility, but she has not denied it. She has taken responsibility. She has repeatedly expressed her regret and her sorrow at her actions. She has not tried to deny it. She did try to get off on the technicality, and she has embraced, for lack of a better word, her culpability, and has accepted that. She has no prior criminal record. She has been compliant with her pretrial supervision. And while there is not restitution at this point in time to the victim in the case, we do anticipate that she will need to make Capital One whole, and she has accepted that responsibility also. And so she truly understands that this has been a very bad experience for Michelle, and she is truly regretful for that. So she do not believe that a term of incarceration would benefit anybody. If she is in prison, she cannot make the restitution or payment to Capital One because she won't have income to do that. She is still currently working. She has been compliant with her pretrial supervision, and we do believe that she would be successful working with community control. And so we would actually not send her to prison, but to allow her the opportunity to prove that she would be compliant and would be a good candidate for community control.
Ms. Peacock, anything you'd like to say?
Yes, sir. I just wanted to express again how sorry I am for everything that occurred. And I am in treatment with a therapist that I actually trust enough to be honest about the issues that I go through. It's the longest amount of time that I've ever seen a therapist consecutively. And I don't foresee anything like this ever happening again. And I just wanted to express that. That's all, Your Honor.
I have a question. I meant to, not of you, of the attorneys. I meant to look at this last night and I did not. And I know there have been some recent changes in the restitution statute, but at this point, is there an option to order restitution to the credit card company? They're the true victim here.
We've contacted Capital One and they are seeking restitution.
Okay.
Which is honestly typical of a credit card space.
Okay. The other thing is I did review the victim impact statement and I saw no comment in there about request for prison payment, but not prison. So that's a little bit unusual. Normally the victims, even when they agreed to something else, often will put in there that punish to the full extent of the law and so forth. But,
Your Honor, we spoke with the victims on the phone on January the 26th, and that is what they stated to us.
well, I have a victim impact statement that was received at the victim witness office on the 11th of February, but I'm just stating what's in there that in terms of the sentences that will pay the bill, present credit card companies hold it back. But there's no other reference to what the sentence ought to be. I take a real good view of people taking advantage of the elderly. Unfortunately, I'm in that category now, defined by the law. But I know that you don't have any prior history. You did take the responsibility. You did cover this up for a while by keeping current on the payments. But it's a real none for me because, on one hand, taking advantage of people like this happens often and it's not discovered, or if it is discovered, it's not reported. And those folks have to be protected. And on the other hand, looking at your history, and I see there is a bona fide diagnosis here of a mental condition that you've been treated for. And this is certainly the situation I think was well, not unique, certainly not one that occurs all the time. So I have to balance both of these things. And I see now that you're actually living in Topeka, Kansas. Is that correct?
No, sir. My daughter moved to Topeka.
As you listed it, and the report said you moved there with her.
No, sir.
Well, you're not where are you living?
I'm living at 6201 State Route 138 in Hillsborough.
Okay. All right. Are you living there alone?
No, sir, I
You
do,
live-
but I live there with my fiance, Casey McCall.
Well, what I'm going to do is this. I'm not going to sentence you to prison. I'm going to sentence you to community control for a period of 3 years. There will be, these are the conditions. First of all, you'll be in the supervision probation department. You'll be required to obey all laws of all jurisdictions, conduct yourself in all body and manner at all times. You're to report, but you must be truthful in all statements you make to them and answers you give them the questions they ask you about the supervision. You're to keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility or communicate with anyone who's an inmate in those facilities without prior written permission. You're not to purchase, possess, own, use, or have under control a firearm, ammunition, data, or weapons of any other type. You may not purchase, possess, use, or have under control any type of controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance, has effects similar to controlled substances, drugs of abuse, or any instrument, device, or thing may be used to administer them, prepare them for administration unless you have a lawful prescription, a copy of which you must provide within 24 hours of receipt. You're also to submit drug testing when and as requested. You may not purchase, possess, use, have under control any kind of alcohol beverage, nor may be present places of sold or being consumed even so otherwise lawful. You're not to associate with anyone who is an inmate in the facility or in a cook-med in this case, and I believe it were or any other person who has a criminal record, a member of a gang, or other criminal group, or any person who has past or could in the future, including you commit a criminal offense, or violate these conditions unless that's approved in writing by a supervising officer, applies to any family members who are living, except those who are living with me for commission of this offense. You may not, after the date of this order, marry or establish cohabitation, common law, or type of relationship with another without written permission. Doesn't apply to your current relationship. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. Then provide your supervising officer financial information and records so you're willing to pay fees and costs will be reviewed. If you're referred for an evaluation or assessment for any kind of treatment, therapy, counseling, training, or other educational programming, you're to undergo that assessment or evaluation, and if there is any kind of a recommendation, then you are to enroll in and successfully complete that. You're to pay the court costs and maintain arrangements to do that. And you're working just part-time right now, right?
Yes, sir.
Well, as a condition of the community control, it's ordered that you serve 60 days in Highland County Jail, beginning immediately taken into custody when you conclude this hearing. Also, additional condition would be that you're not to have any employment as a personal caretaker or in a kind of fiduciary position, meaning one in which you handle other people's money or legal affairs. Also to comply with your mental health treatment program. Thank you.
Yes, sir.
You do get 2 days of credit for 60 days that you're ordered to serve with the sheriff's department. There'll be no fine imposed. And since this company is not seeking restitution, there won't be any order of restitution. The order to pay, you're also going to pay the court costs as a substantive order. If you don't maintain the arrangements and maintain that, do that, then the court can collect that through various means, including lending on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court can order you to do service, give you credit for each hour work, an hour wage, second, for each hour work, boost your credit by that amount, so pay it full. Now, in the event that it's felt that you have failed to comply with these conditions, then the county probation department will file a written notice of that with the court. You'll be given a copy of that. You'll be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing is that you have failed to comply, then at that time, the court will revoke your control and then sentence you to 36 months and fine $10,000. If that happens, once that first term completed, the law provides that the cultural authority may, at their option, place you under post control supervision for a period of up to 3 years. They don't have to, but they can. It's up to them. If they do, and you violate any of the conditions that they've set forth, then they can return you to prison even though you serve the entire term that was ordered by the court for an additional period of up to 9 months for one violation and half of the prison term for all violations. But if your violation is a felony, then in addition, order to sentence the judge in the new case and postponing that judge is also authorized to sentence you in this case to an additional period of 1 year or whatever time done on the period of motion control, whichever is greater. That occurs, that must be served consecutively to the sentence in the case. All right, is there anything further, counsel? All right, now, once you get out of jail, I'm sure the probation officer will see you as far as you can, you'll be in jail. You should leave that in for the probation department on the end of business of the day you are released, unless it's after business hours, and then by the end of the next day. So you'll make sure you report. Because 60 days is just a condition. That's not your legal control.
Yes, sir.
And again, it will be watched closely because, like I said, this one was a real close call. All right. Okay. Thank you.
Stand back to Deputy Thompson, please.
William G. Sowers. Case number 20 CR 274, State of Ohio versus Liam Gage Sowers. Present for the state, Attorney Collins. Present for the defense, Attorney Dennis Hurt. Are you Liam Gage Sowers?
Yes.
Right. Mr. Sowers has entered a plea of guilty to aggravated possession of methamphetamine and first-degree felony. The matter was referred to the probation department for a pre-sentence report. I have reviewed that. Have each of the attorneys received a summary?
The state has, Your Honor.
We have, Your Honor.
All right. Anything from the state regarding sentencing?
No, Your Honor.
Mr. Kirk?
Thank you, Your Honor. My client would ask for a call plea agreement. My client did go to pretrial, which I guess is now known as another chance. He does have a gap in service reported to me as yesterday. He was established back for another chance. Reported to me that he, as noted in the PSI, he did not attend his appointment. He stated that he's been struggling with depression. And based upon the information given to me, it appears that he's definitely in need of some services here to address that, as well as substance abuse. So I would ask the court to grant community control and any appropriate mental health and substance abuse treatment, whether that be outpatient or residential, that the court deems appropriate. Thank you.
Mr. Sowers, anything you'd like to say?
Yes, I've been trying to. I got my girlfriend home. I'm her primary caregiver, and I kind of have a codependency thing going on with her, and it was really difficult to get her home out of jail.
Get her home from where?
From Fayette County.
Well,
So-
where in Fayette County? What was she in?
She was in a bind of her own.
Was she in jail or was she in a care
She was in jail.
facility? She was in jail.
Yes.
All right, so you got her home from jail.
Yes.
How'd she get home? Did you go and get her?
Yeah, I went and got her.
That was nice of you. It was a violation of your pretrial supervision, but it was nice of you.
Was it?
Go ahead.
And since I have a home, I'd like to continue my community control. I'd like to do my PSI done and do everything I'm supposed to do. I would even go to an outpatient facility if need be, or possibly even drug court. You know, I'm just trying to get my life together, her life together. And without me being there, I don't know if she'll have a place to stay. and she struggled with suicide. It's just been a hard time for me.
Anything else you'd like to say?
No, I would like to apologize to Eric for letting him down. I know he wanted me to pull through with the pretrial probation, but I just couldn't get out of my house. Just been depressed. I know I had things to deal with, but I mean, a lot of times I didn't even get up to eat. But now that she's home, you know, I started pulling it all back in together. So, I mean, that's really all. I'd like a second chance to get all this stuff dealt with. I mean, I don't want to go to prison. I just want my life to get back together. For my mother, my family, and for Sasha.
Anything else?
That's all you're on.
Mr. Towers, you know, I see a lot of people in here who are clueless, but I'm not sure that I've seen anyone more clueless than you.
I'm pretty.
You don't talk now, I talk. You had your chance, now I talk, and you remain silent. Now, you never reported for pretrial supervision. We had some hearings, I told you to report, you never. Well, since February, I should say, February 22nd. Before that, you had reported 3 times and either tested positive or admitted to using drugs, and then on the 22nd you admitted. Then after that, that's the last time you were seen. They tried to get you to come in, left voicemails for you, contact you, and you did leave a voicemail on the 4th of March, but you didn't come in after that. You didn't go in for your pre-sentence report appointment and failed to reschedule. You went to Creel, and well, now is another chance. They just had a change of ownership, and they gave you a plan to attend groups 3 times a week and individual counseling 1. And you went a couple of times to group, then once individual, then told you didn't want to do groups, and they told you that the court would enforce that. You were leaving at your peril, or not going at your peril, and you went ahead and did it anyway, and tested positive there. And you just told me, give me the sad story about your girlfriend, fiance, whoever she is, about her dependency, and again, it's a shame for her, but it's not an excuse for you to not comply with pretrial supervision, one of which is house arrest. You just told me you went out and got her, they came and brought her home. And let me tell you, the worst thing in the world for a person that is battling substance use disorder is to live with another person in the same boat, and that's you two. Because contrary to popular belief, you don't help each other, you hurt each other. It's just constant triggering and reinforcement, negative reinforcement. And your behavior shows clearly that you won't even report to probation, you won't even go there to give them the information to report, and you won't go to treatment. So clearly, you don't understand that what I told you before was not simply a suggestion, it was an order. And you repeatedly have violated that order. And if you can't even comply with pretrial supervision, you won't go to treatment, you won't report, and you continue to use, you don't want help, you just don't want to go to prison. And I understand that. Nobody in their right mind wants to go to prison. But unfortunately for you, that's where you're headed. You sit down and be quiet.
Please.
You sit down and be quiet. Ma'am, if you open your mouth again, you're going to be in trouble. Okay? Now, he made his own problem, and he will deal with that. You have your own problem, you can deal with it. Now, you are sentenced to the Correctional Reception Center in Orient, Ohio, for a period of 24 months. I will tell you that I will consider this release after you've been there for 5 months. And at that time, then we'll see if there's been a change in attitude. Now, in the event that you don't get judicial release, and that's not a promise, that's just a possibility, then upon completing that term, you will be subject to being placed under post-release control supervision for a period of 3 years. It's optional, the adult parole authority. The court doesn't have anything involved with that. And if they do, that means that you will be supervised on the conditions they set, and if you don't comply, then they can return you to prison for an additional period of up to 9 months for one violation of a maximum of half of your prison term, which in this case would be 12 months for all violations. But if you committed a felony, in addition to whatever sentence the judge in the new case can impose upon you, that judge is also authorized to sentence you in this case to an additional period of 1 year, or whatever time left on that period of post-release control, whichever is greater, and if that occurs, that must be served consecutively and sentenced in the new case. You can also order paid court costs, and judgment is granted for that. If you fail to do that, then the clerk can collect that reserve, including levying on bank accounts, wages, and earnings, or assets you may have. If that doesn't collect it, then once you complete your prison term, if you're not granted judicial release, then the court can order you to do community service, give you credit for each hour you work, and an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid. All right, is there anything further from council?
Was our judge there?
Oh,
One.
1 day. All right. Okay, you're remanded to custody.
Step her on the screen, Deputy Thompson, please.
Austin Hildebrand. Case number 21 CR 20, State of Ohio versus Austin Nathaniel Hildebrand. Present for the state, the county attorney and Collins, assistant prosecutor Anna King. Present on behalf of defendant's attorney David Wagner. And are you, Austin Nathan? Just Austin Hildebrand, sorry.
Yes, sir.
All right. Mr. Hildebrand has entered a plea of guilty to failure to comply with the order signal of a police officer in third-degree felony. The court ordered a pre-sentence report, and I have received that and reviewed it. And each of the attorneys received a summary.
Thank you.
I have, sir.
All right. Anything from the state regarding sentencing?
Only was it contained in the plea agreement, Your Honor. There is a restitution in this case in the amount of $1,000 to Dwayne Hildebrand.
Dwayne Hildebrand?
Dwayne, D-W-A-Y-N-E, and then Hildebrand, H-E-L-T-E-R-B-R-A-N-D.
Oh, not the same thing.
Correct.
Okay. That Dwayne was an E or just the D-W?
D-W.
Okay, thank you. All right, Mr. Wagner?
Yes, sir, Your Honor. We would ask the state, the court's call a recommendation to the state. Austin's been at the Massey House now for quite some time. We spoke a little bit ago. I checked up with Commissioner Virgil. He indicated to me since he's been at 18 years old, this is the longest stretch he's been clean, 87 days. And I mean this sincerely to my client. I wish him the best of luck. We asked him for community control and a complete treatment. He goes to prison now. I've done this 20 years now. This year, I judge some of my he'd be eating a lot. He's 27. He's a nice guy, but he would come out worse for wear. I wish him the best of luck. His sobriety. I hope he pulls through. Like I said, I didn't mean that. Say that be mean to him. Just prison is not a place where this guy needs to get. his sobriety in check. I see him wearing his sobriety badge here. Hopefully he is sincere about this. If he does community control, I do think he can be a productive citizen. I'm not reiterating, I just don't see a guy like this surviving a prison sentence, Your Honor. Hopefully he understands that, and he uses that as a tool or a crutch to get through his sobriety problem.
All right, Mr. Hildebrand, you have anything you'd like to say?
Yes, please. A long time I've been clean since I've been 18. It's been a long time since I've been there. Massey House worked out very productively for me. It's helped me out a lot. I've been almost 87 days clean now. It's the longest time since I've been clean. I've got a lot of problems that I got to deal with, and Massey House has helped me out a lot. I thank the court for allowing me to take time to talk to you guys. I do wish to stay in the Massey House if possible. That's all, Your Honor. Thank you.
He's waiting on Ben to come back. He took the property to the mother. So as soon as he comes back.
All right. Well, I have reviewed the pre-sentence report, and everything you have is some misdemeanors. See, this is the first serious offense, and of course, this felony is a major offense. But in this situation, you don't have a prior history, and you don't have any other charges pending. And the fact that you are a young man and might not do well in prison, that's not a justification for not going to prison. Because if the crime and the person deserves it, it's going to happen no matter what happens to them, because they chose that path. But Mr. Wagner is right. People like you could end up being treated very badly. So hopefully that will be enacted in the Senate. But I will also say this, and experience has shown that this simply wanting to stay in prison isn't enough to keep people sober. And so I hope that you take the opportunity given you here to get sober and stay sober. Because if you come back with another offense like this, the chances are you're going to go to prison. So it's a judgment order of the courts that you be placed under 3 years of community control supervision under the supervision of the county probation department. You'll be required to obey all laws, all jurisdictions, conduct yourself in all time, manner, and all times. Must report when and as directed, be truthful in all statements you make to them, as well as answers you give to them about questions they may ask you on your supervision. You must keep them informed of the residence and place and form at all times, and not change either without prior permission. Not permitted to leave the state of Ohio at any time without prior permission. If you do, you must have that pass with you when you leave. May not err upon the grounds of any correctional facility or may communicate with or attempt to communicate with anyone who is an inmate or prisoner in any such facility without prior written permission of your supervising officer. You may not purchase, possess, own, use, or have under control any firearm, ammunition, dangerous orders, or weapon of any kind. You may not purchase, possess, use, or have under control any kind of controlled substance, drug of abuse, CBD oil, kratom, or any variant analog of any controlled substance that has effects similar to controlled substance or drugs of abuse or any instrument, device, or thing. It may be used to administer them or use them unless you have a lawful prescription. You must provide a copy of that and it requires a receipt to the probation department. You're to submit to drug testing when it has directed. May not purchase, possess, use, have under control any alcoholic beverage, nor may you be present in places where the sold or being consumed, even if otherwise lawful. You're not to associate with anyone who was a co-defendant in this case, hopefully there are any, or any person who has a criminal record, a member of a gang or a criminal group, or any person who has some passion for the future. Unless you commit a criminal offense to violate these conditions, unless that's approved in writing by a supervising officer. Find any family members that fall within that definition and accept those who you're living immediately before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type relationship with another person without written permission. You must report any contact law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees and costs can be reviewed. If you're referred for an evaluation assessment or any other type of treatment, therapy, counseling, training, or education programming by probation or treatment facility, you're to submit to that. And if there's a recommendation that you complete any additional programming, then you're to roll in and successfully complete that. You're paid court costs and make payment arrangements with the clerk to do that. You're also to do 4 hours of community service at the rate of 20 hours per week for 20 consecutive weeks unless you're employed at least 20 hours a week, full-time student, or you have documentation for position or prior disability finding you physically unable to perform that service. I know from your report, you've only been employed 1 day in your life, and I find that sound. I was employed from time as well. And so working in a community will give you an idea that you can be doing something productive and hopefully make you understand it. You have to be working to make money instead of depending upon other people and society to take care of you. You successfully complete the substance abuse disorder, which is SUD in the entry, residential treatment at Massey House, and any recommended aftercare. Now, by being placed on community control, rather than being sentenced to prison, you're deemed to consent to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property placed under your control or where you're found at any time by any officer of the probation department. There won't be any fine imposed. I am required to suspend your driving privileges for 3 years, mandatory, and that'll begin. Let's see, this offense was January 12th, so I'll make that effective January 12th of this year. Now, once you completed treatment, court will consider giving you limited driving privileges permitted by law upon proof of financial responsibility, but you do have to be otherwise legal to drive, so you'll have to either have a license or I can't give you permission to take the test to get a license, which then becomes suspended because of this order, but that's technically the way it works. But I can't just give it to you unless you do have, you're otherwise legal to drive. And if there are other court suspensions, you have to deal with those as well. You're ordered to pay $1,000 in restitution to Wayne Culture Brand through the victim restitution escrow account at the victim witness office, and service fees charged for that. And you have 36 months to do that. You won't get off community control until you do that. So if you don't have to pay it off 3 years, the likelihood is that I'll extend it to 5 years, because I can't give you up to 5 years community control. I don't like to do that if I want to be shorter or longer, but sometimes we have to do that. But once you get out and you're working, you need to make arrangements to make that payment. Now, if you're also paid court costs as a substitute order of the part of the sentence, and if you fail to pay or make payments, then the court can order you to do additional community service beyond that I've already ordered, and give you credit for each hour you work in and out of a set by the court. Each hour you work will reduce your judgment by that amount until paid full. Now, in the event that it's alleged you fail to comply with these conditions, the adult or the county probation department will file a written notice of that in court. You will be entitled to have a hearing and be represented by counsel. If the outcome of that hearing is that you fail to comply, at that time the court will revoke your community control and sentence you to 36 months in prison for $1,000 to $10,000. If that happens, once you complete that prison term, the law requires that you be put under 3 years of post-release control supervision under conditions set by an adult parole board. And that means you'll be supervised by a parole officer, and if you are found by the parole board to have violated those conditions during that 3-year period, they can return you to prison to make a certain additional period of up to 9 months of any violation, one violation. There is a cap of whatever prison term the court proposed for all violations, but if you committed a felony, then in addition to whatever sentence the judge in that new case can impose, that judge is also authorized to sentence you in this case for violating those conditions to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. That occurs, that must be served consecutively to the sentence if in the case. All right, is there anything further from counsel?
Mayor,
All right, you're no longer then under pretrial supervision. Mr. Hildebrand, as far as you have information over there, go see him about what you're to do, because you'll be transferred to the probation officer, and he'll have you give you the information on you need to report for that. All right, thank you.
Thank you.
Amanda Burr.
Judge, would you buzz Ben, please? Can you buzz Ben? He should be back. I don't know why he didn't come back in here.
Just want to make sure you have.
Yeah. Well, he'll need to help Nick escort down.
All right, case number 21CR007, State of Ohio versus Amanda Jo Verba. Present for the state is Prosecutor Attorney Collins, Assistant Prosecutor King. Present for the defendants, Attorney Dennis Kirk. And are you Amanda Jo Verba?
Yes,
All right, Ms. Verba has entered a plea of, see, wait a minute. This is an ILC.
Yes.
All right. She has filed a motion for intervention in lieu of conviction. I believe that there were stipulated questions just filed, and the court ordered a report. I did get that report. I believe we had to continue this at one point. And I have now received a new report, most recent report that is physically have it March 12th, indicating that she had been attending groups since March 1st, and it had, unfortunately, a positive drug screen on the 4th, 9th, and the 11th of March. That's Ms. McCarthy, and then I received an email this morning from Officer Fulton, and it indicated that Sargina said that she had been going to FRS, and she was drug tested on the 29th, and it was THC only. Did you do that test, Ms. Sargina? Was that at the FRS?
Yes, it was.
Okay, all right. So, are you going as required for this, Mr. Berger?
yes.
FRS, how often are you going?
I'm going 4 days a week.
Right.
I also applied for sober living.
You're also living, sober living?
I applied for sober living.
Okay, where?
Clean Acres in Wilmington.
Okay, that's a good choice. Okay, then it appears then that she's compliant in the whole program is eligible. Is there anything else that either council will add to the, we're still going forward with the ILC then?
Nothing to say, Your Honor.
All right. Okay. All right, well, the court will then find that she is eligible. Now, heard of, and again, I know you've been in court a couple of times in this, and I don't remember everything I said. I'm repeating myself, it's necessary for it to be in the record of the case. Now, and again, I'm sure you've talked to your attorney, but before we go, I have this agreement to plead guilty and enter granted intervention that's been presented to me, and I know it's in my file, so I've had it for a while. And it is a 4-page document, and what I failed canvas to you. On page 3, I'm looking at a line that says, I entered this plea voluntarily, and it appears to be a signature. You should enter her, right?
Yes.
Is that your signature?
Yes, sir.
Can you recall how long ago you signed this?
Probably a couple weeks.
Okay. You signed it at your attorney's office? And did he go over this with you to explain to you?
Yes.
You understand that it's agreed to plead guilty, which means there won't be a trial in your case. You understand that?
Yes.
Okay. Now, and again, I'm sure he's talked to you about this, and I'm not trying to find your attorney, but I have to make all this clear on the record that you understand. So that's why I'm going through this explanation. Now, and you've been here this morning, you've seen the people have been sentenced. Usually when somebody pleads guilty or is found guilty after a trial, they are sentenced. It could be community control probation, could be prison, could be a fine, could be a combination of all those. And that means that person has a felony conviction. And it's on the record, and it's reported to all governmental agencies. Now, there is a procedure, however, that's being utilized here, and that is called intervention in lieu of conviction. What that means is that if the court finds, and it's supported by the evidence in the file, that your substance abuse and/or mental health conditions were a significant factor in the commission of this offense, then and you are enrolled in a certified treatment program, which you are now, then instead of finding you guilty, the court can put you into what's called intervention with conviction. What that means is that I don't find you guilty, even though you have filed a written guilty plea. I know that it's been filed and is accepted, but I don't make an order finding you guilty because the person is not guilty until they're sentenced. Instead, what I do is I stay the case. That means freezes or stops, and I wait for a report from the probation department and the prosecutor's office. And what happens is you are then ordered to complete your treatment plan and to be under supervision of the probation department under the terms of this program that I previously approved, and the court and the probation department will work with you. Those conditions are not strict as some of the ones you've heard here this morning from people who have actually been convicted. But one of them is very strict, and that is that you must abstain from using alcohol or any drugs of abuse or controlled substance for a period of 1 year. And the reason alcohol is in there is because it can be a different crutch for a person that's in substance addiction. They just switch pressure, so to speak. And so that's why that's there. And so you have to remain drug and alcohol free for a period of 1 year. Now, it doesn't apply to those drugs that you have a lawful prescription for, such as medical marijuana, medical marijuana. But other than that, you're not permitted to use any of those. And if you do, and they file a notice of that, then you're automatically brought back and found guilty and will be sentenced. And so the advantage to you, though, and by the way, I put you on for 2 years of supervision. I could do up to 5 under the law, but I like to do 2 because I think if a person is going to respond favorably, they're going to do it within a 2-year period, and that should be enough. And occasionally I terminate before that if somebody's done exceptional work on recommendation of probation. Now, the advantage to you of this process is this. Even though you're pleading guilty, it gives you the chance to, number one, deal with your substance use problem and or mental health issues that may be present, and get those point where you can control that. And then secondly, and even more importantly, for your future, is that you will not have a felony record, because if you complete the program successfully, once I get that report, the case is dismissed. Even though you pled guilty, it's dismissed because you haven't been sentenced yet, so you're not guilty. And then I go ahead and set the matter for hearing to seal the record, and 99% of the cases, the record is sealed. And occasionally something happens between the time that I dismiss the case and the time I seal it, not very often. And that means then it will be wiped off of all the records, and you'll never have a felony conviction. Now, that's the big advantage. The disadvantage for you is this. This is your last chance to stand on a not guilty plea and defend the charge. So you can't go into intervention, try it, and then it doesn't work out, and they bring you back here and say, all right, you violated it. You can't then say, okay, well, that was worth a shot, now I want a trial. No, if you want a trial, you have to do that now. You can't have it both ways. So that's the disadvantage. And for that reason, I had to explain all these things too. So, you understand that? You need to speak up.
Yes, sir.
Okay, thank you.
Sorry.
That's all right. Now, the agreement states, page 1, that you're going to withdraw your not guilty plea to the charge of aggravated possession of methamphetamine under section 2925.11 of Revised Code, the fifth felony. Further states, you understand that the maximum penalty for that is 12 months of prison term imposed, a minimum of 6 months imposed. There's a fine available of $2,500, and there's a possible license suspension of between 6 months and 5 years. You understand that?
Yes, sir.
And we don't show any records of facing any felony charges in the report. We don't have any other felony cases pending anywhere else, do you?
No.
And again, you're not under community control, parole, post-release control, or probation for a felony from any other jurisdiction.
No.
Okay. Now, as I indicated to you, I have to also explain this. I'll give you the worst case scenario. So, you are put under post-release control supervision. Under intervention, lieu of conviction supervision. If probation feels you're not in compliance, they will file a written notice of that with the court. We'll set a hearing. You will have an attorney represent you at that hearing. If the outcome of that hearing is that you have failed to comply, and either with the treatment plan or with the conditions of supervision or both. At that time, the court will terminate you from that program, and then I will find you guilty, and then you'll be subject to being sentenced. Now, and then once you're sentenced, you will have a felony conviction. Now, you wouldn't necessarily be sentenced to prison at that time. It could be prison between 6 and 12 months. It could be a fine of up to $2,500. And there could be a license suspension of 6 months to 5 years. None of those are mandatory. But let's say I were to sentence you to prison. Once you completed the prison term, then under the law, the adult parole authority can, at their option, put you under post-release control supervision for a period of up to 3 years. It's optional, not mandatory, but they make the decision, not the court. If they do, they're supervised by a parole officer under the terms that they set, and if they find during that period of time that you're being supervised that you violated those conditions, they can return you to prison even though you served the entire term that was ordered by the court for an additional period of up to, in your case, half of whatever prison term the court ordered, or 1/4 more violation. But if you commit a new felony while you're under post-release control supervision, then in addition, whatever sentence the judge in the new felony case imposed, that judge could also sentence you for that committing that offense while under supervision in this case to an additional period of 1 year, or whatever time is left on that 3 years of post-release control, whichever is greater. If that occurred, that would be served secondly with sentence in the new case. You understand that? Now, even if you are found to have failed to apply for a treatment program or the conditions of both, I'm not required to sentence you to prison, as I just explained what the possible prison term could be. I could still, at that time, choose to put you under community control or probation for a period of up to 5 years under the terms that are set by the court. I know you've been in court with personally. That could be for up to 5 years. And if during that period of time probation felt that you were not complying, just as in the intervention program, they would have to file a written notice of that to the court, give you a copy. You would be entitled to have a hearing and have an attorney. At that time, if the outcome of the hearing was that you had failed to comply, then at that time the court would sentence you to 12 months in prison and fine you $2,500 and give you a 6-month license, 6-month 5-year license sentence. So, do you understand that?
Yes, sir.
Now, the charge alleges that on or about June 28, 2020, in Miami County, Ohio, you did more than obtain, possess, or use as 2 controlled substances with methamphetamine in violation of Section 2925 of the Ohio Revised Code, a 5th-degree felony. And again, as I said, that carries a possible prison term from 6 to 12 months, fine of up to $2,500, and a possible license suspension of 6 months to 5 years. Now, do you understand what it is you've been charged with by the state, what they said you did, when or how they alleged you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and comments in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
I'm taking my medication now.
Okay, and what type of medication are you taking?
I'm taking mood stabilizer and my antidepressant, my PTSD,
Okay.
and sleeping meds.
Are any of those medications interfering with your ability to understand what you're hearing or expressing your thoughts or communicating with your attorney or anything?
No, sir.
Okay. If there's anything you don't understand or haven't understood so far, tell me and I'll go back over the cover. If you need to talk to your attorney, you can explain to you better. Yeah, you understand?
Yes, sir.
Okay. Now, you have, let me back up. Has anyone threatened you to make you plead guilty today?
No.
Now, other than being promised to be put into the intervention in lieu of conviction program, if you plead guilty, has anyone promised you anything?
It's all based on me.
I'm sorry?
To get my intervention in.
Yeah, I mean, other than being promised that if you plead guilty, you'll be put into the intervention in lieu of conviction program, you get your treatment and supervision, has anyone promised you anything other than that?
No.
Okay. Now, you have certain rights, as I understand, before I can accept a guilty plea from you. Now, you have right to counsel. Mr. Kirk was appointed to represent you because you were unable to pay for your attorney. Now, he wasn't appointed simply to get the case worked out, but to provide any defense that could be available to you under the law that you would like him to provide. And so, if you decide you do not want to do this, that you would rather defend the case, then he'll continue to represent you, including having a trial if that's what you want. You understand that?
Yes, I understand.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be chosen from a group of citizens from this county, summoned for jury duty under a trial date. After they were selected, the evidence to be presented, they get instructed on the law by the judge. They would decide whether or not the state proved true guilt. They would have to make that decision by a unanimous verdict, meaning all 12 have to agree on a verdict. Now, if you didn't want to have a jury trial, but you don't want to plead guilty, then you could waive in writing, and waive in this situation means to give up your right to have a jury trial. And then in that case, you would have this whole a trial to the court, in which the judge would be the one who hears the evidence. It wouldn't be a jury. The judge would be the one who would decide whether or not the state proved your guilt. You understand that?
Yeah.
In the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you would have to come into this courtroom and testify in front of you and your attorney and anyone else that might be present. After the prosecutor is done asking those witnesses questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. So if you have any witnesses that you're not certain are going to come in voluntarily, at your request, the court will issue a court order that's called a subpoena, and that forces those witnesses to come to court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
So,
Now, under the Constitution, Mr. Kirby, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. Prosecutor can't, the judge can't, it's your decision. If you decide not to testify, the fact that you did not testify is not used against you in any way by any person at any time in the case. And in fact, no one's even going to talk about it, with one exception. If there's a jury trial and you do not testify, the judge does instruct the jury that because that's your right, they cannot consider it for any purpose. Do you understand that? Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof is on you to prove you're not guilty of this charge. The burden is on the state to prove that you are guilty. And they must, at trial, you're not even required to present any defense at all. You may, but you're not required to. Whether you present any evidence in defense of the charge or not, burden of proof remains on the state of Ohio. Prove your guilt by proving beyond a reasonable doubt on every essential element of the offense charge, and that's the highest burden of proof that's known under the law. Do you understand that?
yes, sir.
Right now, you originally entered a plea of not guilty. Not guilty plea denied the allegations in the indictment, denied you committed any crime, and that exercised or invoked all these rights I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of a not guilty plea. Guilty plea admits the allegations in the indictment, admits the very crime that you committed that crime. That plea waives gives up all the rights I've explained for you here this morning, except your right to have an attorney. And you always have a right to have an attorney no matter what you plead. But with that exception, your guilty waives gives up your right to a jury or court trial. It waives gives up your right to confront witnesses in open court and to have them cross-examined by your attorney. It waives gives up your right to use the power of the court to tell or force witnesses to be in court for you, the same as the state. Waives gives up your privilege against self-incrimination because you're the one saying you're guilty, so that's what you find you guilty. It also waives gives up your presumption of innocence because if you say you're guilty, then the state's not required to prove you're guilty. Now, a plea of guilty subjects you to be sentenced immediately by the court if that were to happen. And it also waives gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to maximum sentence and under other limited circumstances you file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Ms. Burbank, you're a U.S. citizen?
Yes.
All right. If you have any questions about the intervention in lieu of conviction program or your treatment plan or anything that's going to be required,
No, sir.
do you understand?
Yes.
Do you understand the consequences if you don't comply?
Yes.
Do you have any questions about the charge or the possible penalties if you should be found guilty?
No.
You understand?
Yes.
You have any questions then about the plea agreement?
No.
You understand?
Yes, sir.
You have any questions about the constitutional rights of the plaintiff this morning?
No, I do not.
Do you understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what the consequences of that are if you enter it here this morning?
No, I don't have no questions.
You understand?
Yes.
Now, is there anything you need to speak with Mr. Kirk about before we go any further?
No, sir.
Do you have any questions about anything that I've explained to you here this morning?
No.
All right, then, Ms. Burbis, it's your decision to enter a plea of guilty, as set forth in this written plea that you've provided to the court.
Sorry.
Is that your decision to go ahead and plead guilty? All right. Then as to the charge, which alleges that on or about June 28, 2020, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 Ohio Revised Code, a fifth-degree felony of aggravated possession of methamphetamine, carrying possible prison term from 6 to 12 months, fined up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Thank you. Be seated. All right, the court finds then that on this day, in open court, defendant advised of all their constitutional rights, made no intelligent, voluntary waiver, same such for 11. Please accepted and order filed. The court finds that the defendant's substance use disorder, addiction, and/or mental health was a contributing factor to the commission of this offense, and that she would benefit from treatment and is unlikely to reoffend if provided a course of treatment. And the court finds that she is otherwise eligible under the statute for this disposition, that she is in the treatment for the certified treatment program in the state, is otherwise eligible for community control sanctions, is not a repeat or dangerous offender. And therefore, it's the order of the court that the defendant's guilty plea be accepted and filed. However, there will be no finding of guilt at this time. Rather, the court will stay all proceedings in this case and await a report from the probation department or prosecutor's office. Then it will be under control and supervision under the conditions of this program that I've previously filed with the court, and those will be given to you and go with you go down to the probation department. You're to successfully complete that intervention plan, treatment plan, and also must abstain from using drugs or alcohol for a period of 1 year. Other than those for which have a law prescription. You are to comply with all the conditions, as I said, that the probation department has and I previously approved. And if you're also pay the court cost of the proceedings. Now, if you successfully complete your intervention plan and comply with all conditions of supervision, then upon notice of that from the probation department and the prosecutor's office, the court will dismiss this charge. We'll set the matter for a hearing sealed record, and it's almost guaranteed it will be sealed. Now, if you fail to comply with either your treatment plan or any of the conditions that you're required to comply with while you're being supervised by probation, then they will file a written notice of that in the court. You'll be provided a copy of that, and there will be a hearing, and you will be represented by an attorney in that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court will terminate your intervention program conditions, find you guilty, and then the matter will be set back on the docket for a sentencing. And we proceed then in sentencing, and it could be controlled for up to 5 years, or it could be a sentence of 12 months in prison, a fine of $25,000, and a license suspension of 6 months to 5 years. All right. Now, is there any further discussion? All right, now you're no longer under pretrial supervision, house arrest conditions, those things, so no longer apply. See Officer Archie over there, or him to be the time when you need to come in and go over the new conditions and start to do supervision. All right, thank you. Ashley Myers.
Thank you. On the record for Myers, Your Honor.
Case number 20CR 266, State of Ohio versus Ashley Hayes Myers. Present for the state are the prosecuting attorney Collins and the assistant prosecuting attorney King. Present for the defendant is Jacob Wire. The defendant is not present, and I'm not surprised. How about you? I shouldn't ask that question that way. Have you heard from your client?
Only because I spoke to Ms. Sturgill a couple of weeks ago. She told me Ashley walked away from treatment.
Right. All right. She walked away from treatment after I let her out of jail and expressed conditions she remained in treatment March 29th, and I presume you heard nothing from her since?
No.
All right. And there was an affidavit filed on the 1st of April, but I held it until today to see if she might show up. But I hope it brings eternal with them. Again, I'm not surprised. So the court will order that the matter be placed on the active docket and a habeas will issue. And once she is taken into custody, we'll notify you, Mr. Becker, and the matter will proceed with a sentencing hearing in that month.
Yes, sir.
All right, thank you.
Thank you.
Your Honor, is Ronald Humphrey still on the inactive? Is he on an active docket?
Is that-
Ronald Humphrey?
No, he's an active, we have cases on him.
Okay.
So this file yesterday. I knew he right. Are you Mr. Stewart?
Yes, sir.
All right, we'll go ahead and start your hearing on state. Go ahead.
Ben's getting the indictments ready for 11 o'clock arraignments. So.
I see right there. Make sure your phone's off that way.
It is.
Okay.
On the record, Justin Stewart.
Okay. Case number 10, CR 215, State of Ohio versus Justin Stewart. Attorney of the United States, prosecuting attorney, and Collins, assistant prosecutor King. And you're Justin Stewart?
Yes.
Mr. Stewart, attorney, representative. Mr. Stewart was convicted of possession of heroin, a 5th-degree felony, and was placed on community control back, it looks like in 2011. So he did complete the STAR program, and was successfully discharged from supervision. Mr. Stewart has filed a request to have his record sealed. So the court set out a hearing in order for probation to provide a report which I have received. And I know that court costs have been paid in full, also the deposit for the sealing of the record. Mr. Stewart, is there anything you would like to add in addition to what you put in your application?
I mean, basically, no, not really. I mean, I put it in there. You know, I've come a long way.
Yes, you
I
have.
have a really good job, you know, a salary job. I make really good money. And took a long time to get there. And I kind of, there's some projects I get on where it's a federal job. And I just go ahead and tell them I'm not available because I don't want them to run that background check. And, you know, it's embarrassing. And then moving forward past that, you know, I got 3 kids, 10, 6, and 15 months old. And I was raised locally, you know, in the woods. And it's mushroom season right now. We like to do that. And if I can get this expunged, I would like to see what I can do to also get some sort of gun rights to stay protected while we're out there. Kind of show them the old ways, if that makes sense. The way I was raised. So, here I am.
Okay. I did receive an objection, so.
The state does not object to him getting his record sealed. I'm not sure he's eligible.
For what reason?
Well, his CCH shows that he served a prison term or at least was convicted of a felony in another state.
In another state?
In Georgia.
Yeah.
That was 3 months. That was around the same. That was right after this.
When was that?
2012.
Okay.
And I don't see it on the probation stuff, but
It was, well, it was, no, we don't have it in our report.
It was a first offender. I did a first offender thing, so they made me serve 3 months in county, 3 months in an actual like diagnostic prison, where they take your blood and stuff. And then it was supposed to be sealed because I completed all my.
Yeah, so you understood that was going to be sealed, but apparently you said it shows up on the CCA?
yes.
Okay. Then, could you go into my, gas drawer on the, computer stand on the right top, or else be in the bottom part, applies to sealing of records, no, I have to take a look at that, because and again, we just had a recent amendment to that.
It takes effect on the 12th.
It doesn't take effect till
The
next
12th,
week.
yeah.
But, under the law, if they were non-violent, it was punished up to,
5 altogether, I'm not sure.
5.
Right.
And now, I believe the new law is going to eliminate that altogether. But are you saying it's disqualifier because of the conviction out of state?
I think that puts him over the 5.
5 felonies?
No, he didn't have 5 felonies.
I know, that'd be putting him above 5 convictions.
Well, he has another this one.
Or it may be an offense of violence because he was initially charged with burglary. I don't know what he ended up pleading to.
Okay, here we go. I looked at the memo from your staff attorney, Gil DA, which we're kind enough to share with me. And it says that under current 2953-31A1A, that qualifies as an open offender who has any number of misdemeanor convictions and no more than 5 felony convictions for 4 particular felonies. So long as none of those are offensive violence or a felony sex offense.
Okay, but we don't know, I don't know what the Georgia conviction is.
What's the show on your CCA?
It shows a burglary amended, but
What, do you know what it was?
Yeah, it was a way lesser charge. It was,
theft by taking.
I think, so what, I was so this is right after this, and I was up for a couple of days in a town in Athens, Georgia, which is the Bulldogs, right? Big college town.
Yeah.
So I was up for a couple of days. I was still going through it, and I was with somebody, and they threw a rock through a window, and then I went into that. It was an office building, and I went into the office building with them, and I had a stapler in my pocket, and a stapler and some sort of clip. I have no idea why. I have bits and pieces of a memory of it, but I had a stapler in my pocket. And being out of town, flight risk, and all that, they, did everything they could to convict me. I mean, they had the right. I was in the wrong.
So what was the actual conviction for?
I don't remember. It wasn't burglary. It was a lesser charge, but probably.
He was charged with an F2 burglary. It looks like they reduced it to a theft by taking, but I don't know the level of offense of it.
No, that has to be under the statute, eligible offender includes a conviction of more than 5 felonies in either this state or another state. And includes it as long as the offenses in the other jurisdiction would be 4 to 53 felonies and none are offensive violence and felony sex. Since it's a theft by taking, I believe that's going to be probably 53 felony, if not a misdemeanor under my law. So, in the absence of any proof to the contrary, the court will find those eligible offender. So, anything else?
No, we didn't object, right?
I understand.
We're aware.
Yeah, that's fine. All right, so is for the court then, Mr. Stewart, that your record indicates we'll see on that. The problem we have, federal offense, maybe we'll check into the town in Georgia and see, make sure that wasn't a felony. If it is, we're still going to have that problem. It won't be because of this case will be sealed.
Yeah.
Now, the sealing order will be sent to all the law enforcement agencies and leads and FBI and so forth, and they will seal it and it'll be wiped off the records. However, that may take 30 to 45 days. And the other thing is, it will not eliminate that from any third party that may have evidence of that. So, if you've been through a job investigation, background investigation by a private company, they have a report, and they give it to a employer or prospective employer, those aren't effective. But if that comes up, then you can show them your entry.
Okay.
And you're going to get a certified copy of the entry, we'll have a seal on it, red stamp. Make several copies of that, keep it in different places, because you may be asked to provide proof. And if you give them a copy, don't give them your sealed copy, give them
A copy of
close down to the fax, a Xerox copy. Now, if you should lose all your copies, come back and ask the clerk for another one. Here is the problem. If you walk in and say, I need a copy of my old conviction, or I will seal it and say, we don't have any conviction, it's not correct. We don't know who you are. And then you're gonna have to ask me to put on an entry, reopen your case, to give you a new entry, and then seal it, and that's gonna cost you some dollars for reopening the case. So make sure, that's why I tell people to keep several copies in different locations. Maybe want your parents or safe deposit box or something, just so that you don't have to go to that experience. But it hasn't happened here, but I had a case that I was presiding over in Brown County where I had to do exactly like this. So, we want to try to avoid that. But also, and I will say that you have made a remarkable change in your life. This was your only felony in this state, but did have a lot of problems with this problem. Obviously, you changed for better. So we're pleased to see that.
Thank you.
Congratulate you for that. And hopefully you can get the situation with Georgia clarified and make sure that's not a penalty, so it doesn't affect your future in your job.
Yeah.
Okay. All right. Thank you.
Sir,
Yes.
I do have one question. So,
You want to go back on record?
Yeah.
Okay, 1 second,
Just give me a
please.
second.
I can figure out that lawyer's phone number and call down to the Georgia court. Now, moving past that, is there a way to establish gun rights?
Well,
back at least in my home
this
state.
case will wipe that off. So when you go in for record check, it shouldn't show up. And it should be eliminated, but the Georgia case will still be there. So you best make sure you check down there, and then what I would tell you is I can't give you legal advice.
Yeah, okay.
Just talk to an attorney, to see if there's anything more we can do, or need to do. But, see, our conviction's gonna be wiped off the record, so if they run your background check, it's not gonna show up. Now, it's supposed to be still on, but again, they'll still have another case, and I don't know if that happens or not.
Okay. All right, thank you, sir.
All right, you're welcome.
Judge, do we need to do anything on record for Edwards?
No.
Okay,
No, I made it.
all right.
Okay. Take a break here and then, good night.
She was got anything? After what, a year? Yeah, shocking.
They got their insights too.
Did they?
I sent an email or a text message out to a couple of officers in Greenville. They are amazing. They always find her.
I wondered if the marshals have been after her.
No,
Hampton's still in Ross County, isn't he?
I don't.
Probably sitting in his living room up there in the hill, but they didn't
I
want
don't
to
know,
get her.
but Jay Beatty went to an attic and broke their sides out.
That's good. I hate warrants. They're cases, but it
Well, we have more than we've ever had
should
because
down, trying to keep out of jail. Where's
Don't
that?
work.
Capital Front, last time you did for, yeah. But she's up Saturday.